Okay, I'm going to start the meeting.
All right.
Hi, I'm Paul Zdrodowski, president of the consulting firm HR Partners. I'd like to introduce our other panelist, Mr. John J. Sarno, Esquire, president of the Employers Association in New Jersey. Say hello, John.
Good morning.
I've worked with the Employers Association for over 20 years, providing compensation and performance management services for their members. During this webinar, we will offer you insights from myself, an experienced compensation practitioner, and from John, an experienced labor lawyer. Today's webinar topic is what you need to know about the new New Jersey Equal Pay Act. The act is now in effect and will significantly impact your company. The law is broader than many other state and federal laws, as it applies to all New Jersey public and private employers, regardless of size. Comparison of wage rates shall be based on wage rates in all of the employer's operations or facilities, not just one location. The act applies not just for women. The law covers not only wage discrimination on the basis of sex, but also protects other traits, including race, creed, color, national origin, nationality, ancestry, age, marital status, and a long, long list of any other trait you could practically think of. This essentially means that every single employee of yours is covered by equal pay protection. Any employee who feels that he or she has been discriminated against may file a complaint with the New Jersey Division on Civil Rights within the Department of Law and Public Safety, or file a lawsuit directly with the New Jersey State Superior Court. The law allows for monetary damages for up to 6 years from its first discriminatory pay period. It will be unlawful to require an employee to consent to a shortened statute of limitations or waive any of the protections of the law. The court can require the employer to pay triple damages if found guilty. This really ups the financial exposure companies face. These high monetary damages may motivate a greater number of employees to file complaints than under the Federal Equal Pay Act. John, I know lawyers don't like to say anything about other lawyers, but is there a chance that these high monetary damages might encourage some private attorneys to try to increase their revenue?
Not directly, no. The key, I mean, you've said many things, and it was a wonderful summary of the law. But for me, what is important for our employers to understand is that this Equal Pay Act amends the New Jersey law against discrimination. And while it has certain new procedural rules and new remedies, employees have always had the right under New Jersey state law to file a lawsuit for discrimination, whether it was termination decisions or even, for that matter, pay disparities. So I don't think we're going to see a proliferation of lawsuits, but it certainly does make the landscape much more complex for employers.
Yes, thanks, John. The new law is much broader than the Federal Pay Act and puts a greater burden of proof on the employer to explain differences in wages. In the event that an employee brings a lawsuit against an employer, the employee would only have to show that they performed similar work and worked in similar working conditions, but were paid less. It is then up to the employer to prove that they have not violated the law. The federal law standard essentially says to compare employees doing the same job who are similarly situated. The New Jersey law requires equal pay for similar work. The law does not specifically define the term substantially similar and only states that it is a composite of skill, effort, and responsibility required for that work. I think that that's a significant change from the more strict concept under federal law. What do you think, John?
Well, certainly there are two views here. both by detractors as well as proponents, oddly enough. So when the law was going, when the statute was going through the legislature, those opposing the statute cried, well, this is about comparable worth. And I think that's what you're going with this.
Yes.
And I think certain, advocates and proponents would like this law to be about comparable worth. But I don't think it is about comparable worth. I think it's about equal pay. So, for example, I'll quickly distinguish. And you're absolutely right. The statute does not define substantially similar work. So let's say you have two accountants, and it could be a member of any suspect class, as you've indicated. But let's just say it's a man and a woman makes, say, $5,000 less than a male counterpart. Well, one of the first areas of inquiry is whether they're doing substantially similar work. Same effort, same skills, same responsibility. I think we're going to be talking about apples and apples. That is to say, comparisons within the same job class, accountants to accountants, as opposed to comparable worth, which simply looks at different jobs. So, for example, you can look at an electrician and a nurse and determine whether there's the same level of skill, same level of responsibility, same effort being put into the job. That would be an incredibly complex analysis, which, quite frankly, the average employer is not going to be able to deal with, and I'm not quite sure the courts are even prepared to deal with that type of approach. So I'm pretty sure we're dealing with apples and apples, but at the end of the day, it will require litigation to define and clarify.
Yeah, that's the primary concern I have about the law, is that similar wording. Other states, including California, I think there's about 5 others, have similar wording, and they have gone down the path of comparable worth. So I think that's an issue that is yet to be determined. And if it goes that way, it will have a significant impact on employers, because most compensation systems have pay ranges and pay bands, minimum and maximums, that for the most part are set upon the market rates. That means within those bands, people are paid different amounts of money. And very often, pay bands include more than one job. In fact, some companies have what they call broad bands that encompass a great number of jobs. I think that's where it really becomes complicated for a employer to really defend a comparable worth argument, because there could be as many as 30 or 40 jobs within the same pay band. And that's my concern.
Yeah, well, see, it's a legitimate concern. It's not the greater concern, or at least an equally great concern, is on municipalities, right? Because New Jersey is a small business state, right? And again, the law applies to every employer, regardless of number of employees. So if you have one employee, the New Jersey law against discrimination will apply to you. But like for most small businesses, they're totally off the radar. And in New Jersey, the average business has 9 employees. So you're not going to see this, wide swath of pay bands and classifications. But where you do see these are with large cities and municipalities, which this law applies to. So I think if you're looking for the greatest havoc to be to befall on an employer, it's really the public sector that would have the most to lose if a comparable worth approach is taken. And that's in fact what we're seeing in other states.
Yes, well, I think the issue of small companies is kind of a double-edged sword. First of all, most companies, particularly those less than 50 employees, don't have formal compensation systems.
Right.
which means that they do not have systems in place to substantiate their pay decisions. So that's the negative. The positive is what you said is they're not likely to be on the radar. Typically, under the Federal Act, the Federal Commission looks at large employers to build a case that gets a lot of publicity. And I think that's likely to occur in New Jersey also.
Yeah, I think we've had that experience here with regard to large class actions against major corporations. That's not unlikely. Feel free to attend to, and I'll continue.
Okay.
All right.
The law does allow individual pay differences.
No, I was gonna suggest that you go ahead and deal with your dogs, and I'll continue with the group.
That's okay.
All right.
They'll be quiet. There apparently is a chipmunk problem they're dealing with.
A chipmunk problem. Okay.
The law does allow individual pay differences based on job qualifications, education, and experience requirements for the job. The Act prohibits the employer from taking any reprisals against any employee for discussing with or disclosing any other employees or former employees' information regarding their job title, occupational category, and rate of compensation, including benefits. This section will encourage your employees to ask about their compensation compared to the compensation of other employees.
Yeah, this is significant. So the other good news, back to the good and bad news for a typical New Jersey business, is that these cases are very complex and difficult to prove. So I think what a small business is likely to encounter, if anything at all, is a lawsuit, right? One employee alleging that they're paid disparately from another employee doing the same job. The employer, though, has a defense. Now, even though they may not have, as you suggest, a sophisticated compensation program in place, the employer can assert that performance is not the same, seniority is not the same, and there are other bona fide factors that might distinguish the particular jobs. So the burden is quite high for the employee to allege discrimination. But even if the employee does allege discrimination, the employer does have that defense to be able to distinguish the employees and the work that they're performing. Now, the other thing is as you just indicated, which I think is really the kind of the open door here, is the ability of employees to talk about their wages. Now, an employee can ask about wages of go to the employer, the HR person, let's say, if there is one, and say, I want to know what my coworker is making. The employer does not have to disclose that, but on the other hand, the employer cannot take any adverse action against the employee for asking for that disclosure. So that is going to be a balancing act for the employer to perhaps deny the request, but at the same token, not take any disciplinary action or other action that might be associated with that request.
Another problem is if the HR person does provide that pay information, the employer cannot take any action against the HR person. They're protected under the law also.
Yeah, well, there's a lot of, there's a gray area here because the HR person is the agent of the employer. The HR person is the alter ego, acts on behalf of the employer. So in that regard, the HR person and the employer are legally the same. But by the same token, the HR person is also an employee. So that is an inherent conflict of interest that exists within the HR role, within the legal counsel's role, and other fiduciaries within an organization. So the HR person has a duty of fidelity a duty of loyalty to the employer. But by the same token, that HR person is just another employee that has rights and protections under this act. And one of the protections under this act is that you can't be retaliated against for disclosing information. So I'll tell my HR person, hey, this is confidential information. We treat wages as a confidential matter. Do not disclose it. That HR person, for whatever reason, discloses. I, as the employer, view that as a disloyal act. However, that disclosure is protected under this new set of amendments. So there's going to be some complex ethical and legal issues that arise when the HR person, in effect, becomes the whistleblower.
Yep. Okay. I've got a couple of questions from a practitioner standpoint about the act.
Yes.
One of the most important ones is how the Division of Civil Rights and the courts will enforce it. Will they expand individual complaints and look at the company's overall compliance with the law by requiring charge companies to provide them with vast amounts of payroll data?
Yes. Again, these lawsuits are, so when you look at it, it all looks nice to the layperson and certainly to the employee who thinks that they're going to get a pay increase. But the documentation that is going to be required is going to be voluminous. So in a civil litigation, there'll be document requests for what other employees in substantially similar jobs make. That's going to be disruptive. If the Division on Civil Rights decides to conduct an investigation on behalf of an employee, then the division also has the right to issue a subpoena for documents. So these cases will go on for a long time and probably more likely than not require expert testimony, such as yourself. So, it's just one of those things where, if I'm an advocate for the law, it's sort of like, okay, you have it, but you have to be careful what you wish for. These are very complicated, very expensive litigations to bring.
Yep.
I don't know if the Division on Civil Rights, matter of fact, I can kind of surmise that the Division on Civil Rights, if they are going to take a meaningful role in enforcing this, which they don't have to, by the way, because all of this is private litigation. The employee can go to the Division on Civil Rights or choose not to. It's not like Title VII, where an employee is required to go to the EEOC before they file a civil suit. So it's unclear whether the Division on Civil Rights is up to speed, whether there's a bench there, a talent bench to deal with these issues. And then we're going to see whether there's going to be any guidance, particularly as to what substantially similar work means.
Yeah, I'm concerned that the civil Division of Civil Rights will be utilized more because it doesn't cost an employee anything to file a complaint with them. Whereas if they have to go to court, they have to hire an attorney and incur those expenses.
Well, we can look at the experience with the EEOC. Most of what gets charged to the EEOC is dismissed because, again, the law is technical and requires discrimination. The layperson does not understand necessarily that discrimination is not just this generic arbitrary decision making. That discrimination means that the decision is motivated by bias, whether race, religion, color, those things that you've indicated. So most of what goes to the EEOC is generic kind of allegations of unfairness. And unfairness is not discrimination. So if that's any guide to historical practice, I think what the Division on Civil Rights is going to be getting is just a lot of unfounded charges. The real cases are handled by lawyers, and they're filed in the civil courts.
Okay. We're just about out of time. One final question, John. Do you think this law will eliminate pay discrimination in New Jersey?
No, pay discrimination is so systemic. It's cultural. It's in the DNA of the most organizations. So no, this law will not end pay discrimination.
Yeah, I agree with that. But I think in the short run, because equal pay is such a hot topic these days, any publicity generated by enforcement actions is going to be a hot topic for newspapers. And
Look, yeah.
that might encourage a slew of complaints and lawsuits. But you're right. For cultural reasons, females tend to dominate low-paying jobs like secretarial, clerical, or nursing. Conversely, men tend to dominate high-paying jobs like the trades, engineering, and programming. To totally eliminate pay differences, women would have to significantly change their job choices. Women also often choose to leave their careers at peak earning times to raise a family. Then they have to start all over again many years later and are disadvantaged by changes in the economy and technology. So I agree with you. In the long run, this issue is going to be around for a long time. Okay, let me wrap it up. Understanding the new law and changing your compensation policies to limit your company's liability are just the first steps HR professionals need to take. Determining whether you have inadvertent pay discrimination and deciding steps to adjust the pay of specific employees are the next crucial steps that need to be taken. As you've indicated, John, these steps are extremely complex and generally require outside expertise. HR Partners has been helping clients deal with equal pay issues for over 20 years. To learn how we can help you, please call me at area code 908-763-5699. If you're interested in learning more about the benefits of joining the Employers Association of New Jersey, please call John at area code 973-758-6800. Thanks for your time.
Take care. Have a good day.
Thanks, John. I'm stopping the recording.